We will now move into our second session for the day, presented by Professor Willem Boshoff. Our presentation is called Enhancing Merger Control to Support Economic Growth in South Africa. What is unique about Willem's presentation is it is the only report that was done before the conference. So that one is already available on our website, the full 10,000 words of it, with an executive summary. So if you guys are interested to dive a little deeper, that report is available just like the rest will be eventually. Along with Professor Boshoff, who is professor at Stellenbosch University and co-director at the Center for Competition Law and Economics. I'd also like to welcome James Hodge, who's chief economist at the Competition Commission, Professor Thando Vilakazi, who's associate professor at the University of Johannesburg, and Professor Nicola Theron, who is senior managing director at FTI Consulting. I'll hand over to Willem and we can get going. Thank you so much.
Okay, thanks, Fushia. Thank you. Good morning, ladies and gentlemen. I'm delighted to be talking about competition, because competition, of course, lies at the heart of how economists conceive of the functioning of an economy, the market economy. And as a colleague recently commented, competition has few friends. We all want competition, but we all not necessarily like competition. So I think policies to support competition, including but not limited to competition policy, they're worth thinking about as we contemplate how to enhance growth. So I think it's useful to reflect briefly on the impact of rivalry on economic growth. It is well established that competition affects productivity, innovation, and firms that face pressure will tend to improve things. So that's a long thread in a rather deep literature. It's not so clear how much competition is needed is optimal in any particular market to give you the type of productivity gains or innovation that you may want to see. And this is, of course, reflective of the work by Philippe Ajon and others in terms of understanding market-specific requirements for innovation. But I think at the kind of macro level, the evidence is actually quite striking. So this is from earlier work where I've looked at kind of business cycles and their relation to structural trends in the economy. That South African business cycle expansions, we've dealt with this yesterday as well. Historically, they lack private fixed investment expansion, with the notable exception of the very strong expansion we had from the 90s until around 07, 08. And of course, that particular expansion followed from a period of strong deregulation efforts to introduce competition to key sectors in the economy here from the mid-90s until 2000. It took a bit of time before that found its way into capital formation. And of course, there are a range of other policies and developments that also supported that. But certainly key to that period's strong upswing in performance was the benefits, kind of reaping the benefits of introducing more competition to key sectors in the economy. And of course, what happened from 07, 08 onwards, again, not limited to this, but critically, those dividends from those earlier boosts began to kind of dwindle, and they were not followed up with further deregulatory efforts, which then, of course, gradually stifled productivity gains in the economy and growth. So this is really important. So today, when we were more kind of microeconomists talking about competition, but it really does have a very strong macro link. And just thinking about this at that level, competition is certainly quite critical. We have heard and had a few presentations already on the impact of Now, I'm careful of saying sectoral regulation. I should say something different, Lawrence, maybe just industrial policy, I suppose. Impacts on competition. And so it's certainly not the focus of the paper I'm talking about today, but there's no doubt that that type of regulation is critical and perhaps in many instances even more important than competition policy in driving competition. And this is often underappreciated. So competition policy can only do so much because it receives a certain institutional structure and a certain market context when cases have to be decided on. So that apart, what role can we conceive of for competition policy in particular? So, of course, competition evolves. It's not a static thing, and it evolves as firms respond, even to rather constraining policy conditions. Something as general, such as banking competition, for example, evolved in recent years, in part because technology suddenly allowed new sets of firms to do things that the previous geography-based bank branch network model didn't allow them to do. And despite perhaps a slow entry in the past, you could kind of leapfrog that and overcome the constraints that maybe policy have contributed to. The same goes for several other sectors. So firms change, and an important way in which firms respond to their environment is by buying competitors, buying suppliers, customers, changing. So mergers and acquisitions is a very important barometer of overall corporate activity and sentiment. We've discussed that in the economy. And merger control is designed to help us shape mergers and acquisitions in a way to ensure that these types of transactions do not artificially limit competition traditionally, and perhaps a bit more controversially, but now generally accepted, also to potentially shape competition going forward. So there has been a bit of a change over the past 20 years internationally, just in terms of how we think of merger control. I'll say something about that a bit later. But it's no longer just about protecting existing competition. It's a bit also about enhancing competition going forward. So what I have tried to do in the paper, what I try to give you here is a bit of a synopsis, is to argue that the way in which merger control is conducted has been conducted over the past 10, 15 years, has tended to give more prominence to non-competition objectives as part of the competition assessment. And that the diversity of goals in our merger control regime is probably not desirable, or should be rethought in a way that does not result in weakening the core focus of competition policy, which should be, or merger control as part of that, which should be competition. So competition policy pursues both a competition objective and a set of so-called public interest or non-competition objectives, which I'll set out just now. This kind of split focus gives rise to several problems, some of which I think are more familiar, and maybe just for my discussants, the way I present it here is a bit different, just to unpack it better for an audience that may be not working on competition issues. But it gives rise to the familiar problem, as in monetary policy, time inconsistent behavior. So what you want to do ex ante is not what you want to do once you see the merger or whatever in front of you. We'll talk about that. Leads to increased numbers of mergers being conditionally approved, where the purpose of the condition is to deal with the public interest issue. Of course, mergers will attract remedies to deal with competition issues, but when it comes to non-competition issues, that has really increased significantly. Adjudication times have risen in no small part because of the increased emphasis on those public interest issues. And in general, coupled with that, probably going with that, a more general widening or change in how competition is conceived, away from the idea of rivalry. And this kind of broadening, as I set out in the paper, gives rise to effectively a tax on mergers and acquisitions, an additional tax which is quite substantial in large transactions, but also very likely deters mergers. And this is something that's very difficult to measure. We don't observe mergers that are not tabled or abandoned before they've been filed. And so as we think about ways to enhance growth, enhance investment activity in mergers and acquisitions, this is something that is worth thinking about. So just on some of those individual challenges, competition, like in competition policy, like in monetary policy, entails there's an ex-ante commitment to preserving competition or advancing competition, if you want. So the idea is that if a merger ex-ante is filed that is generally found to be pro-competitive, on balance, that should be approved. Of course, there is, once you have multiple goals, like in monetary policy, where you could conceivably pursue both inflation and growth, you have the goal of both doing competition and advancing certain non-competition aims. There is the incentive, perhaps, to expose, once the merger has been filed, to focus on specific issues that are not related to competition. And so that tension is, in my view, exacerbated by how the competition policy, or specifically merger control, is set up in the Act. Not necessarily how it is executed, but how the Act looks at both advancing competition and non-competition goals, and critically, in my view, allowing for ministerial intervention in these cases. So, I should forget to move on this side. So, what we need to think of is a need to limit the goals of merger control in a way that is reflective of the evidence and that retains the primacy of competition policy. At the moment, the Minister of Trade, Industry and Competition has significant influence in terms of how to participate as an intervener, make representations, recommend appropriate conditions, or agitate for them. And here, also in a way familiar perhaps to a central bank audience, you have the tension between de jure kind of a role and a de facto role. And so de jure, it might look as if the minister doesn't have all that influence, but of course in the back room here, lots of things are going on. And those types of deal making really does have an impact, I think, overall on business sentiment. So we need to think very carefully about exactly what we want from ministerial participation, I suppose, in our competition policy system. Related to that, so we need to think about ways to improve independence of our authorities and enhance that independence in a way that limits how they interact perhaps with the DTIC or other parties. A sort of secondary point I also make in the paper is that there is the need for perhaps increased accountability. I think here it is less about monitoring whether the authorities are doing their jobs, but rather who's involved. And again, that might help shed light on why certain conditions have been imposed in cases, who's been pushing for them, and so on. So this is a difficult area of reform, but it is one that is where we might draw some insights, for example, from the German system, where they have a separate body whose one of its principal functions is to actually just review the work of the competition authorities, just in a way. So there might be something there to further strengthen that. So beyond that, I think at the core of the paper is just the ideas around how we might think of and going forward frame our non-competition objectives as part of our merger control. So at the moment, our law allows for a variety of these public interest factors. That I've put them in the little boxes. There are not 4 of them, there are more, but just in terms of the types of things that authorities are required to think about: employment, effects of a merger, its impact on SMMEs, its impact on regional industry competitiveness, its national competitiveness, empowerment, and so on. So, the facilitating conditions for the time inconsistency I've discussed are really created by this requirement that you have these 2 sets of goals, and that you have to apply when evaluating a case. When the Act was originally written, it wasn't as extensive, but the public interest factors were certainly there, but they had enjoyed a secondary position. So the competition was the principal issue. And gradually that has changed well before the Act was amended in 2018, already from 2010 onwards with the Walmart case. There was increased appetite to use these kinds of conditions, or to push for them, at least from the ministry side. And that has resulted now in a situation where we have equal footing. So in South Africa, mergers are equally evaluated on these 2 grounds. So you might have a merger that does not weaken competition, but that conceivably may be seen as harming these non-competition objectives, and that could, and hasn't led to that, and there was one case where the earlier stages involved it, but it could lead to that mergers being blocked. So it is not simply kind of technical academic exercise. These risks are there. Now, and that has given rise, predictably over time, to what a few students of mine and I have been working on over the past years in terms of modeling the increase in the number of conditional mergers. Conditional mergers meaning here mergers which attract a certain remedy, where the merger is not just approved, you have to do X, Y, and Z in order to get to approval. Right? And that has increased, but at the same time, that has also given rise to, on average, an increase in the duration of merger approvals. So especially, it's maybe not that significant if you look on average, but for the larger mergers that's recently been approved, there are quite a few cases where these duration of merger approval is quite long. And that has an impact in terms of corporate decision making and kind of sentiment towards M&A in the country. So my departure point is just to kind of say, well, if we want growth-focused merger control, what kind of ancillary objectives, additional objectives might you want? And then it's the argument I'm making in the paper is that one should think of probably objectives that center broadly on kind of industrial or very selective, but industrial policy type aims. Because these align best with competition aims, so that you could think of that you are advancing a certain perhaps sectoral competitiveness or certain value chain. It would be very much in line with current international debate and kind of policy argument, especially in the EU, where there is quite a bit of discussion on how competition policy kind of advances certain industrial policy aims, for example, for government. But it is, in a certain sense, our framework or overall approach, where we do have these alternatives, is a certain advantage, right? So we actually have been doing this, what many have been debating. But what is interesting is that these the debate in the EU is not necessarily focused on adding objectives. So let's do competition and do something else. Actually, the discussion is a little bit more about how do we think of competition? And how kind of talking about competition is in a dynamic sense. So the idea that competition should be viewed not, or a merger's effect should be assessed not just in terms of its actual immediate effects on the market, but how it shapes how that market goes forward. And of course, there's also a focus there on a so-called innovation defense of a merger, so that if a certain transaction is actually anti-competitive, it might be justified if it does enhance certain innovation capabilities in the EU in that particular case. Now, I'm not saying we should emulate exactly that, but it is interesting that it is possible to focus on competition and still advance something broader than just worried about, say, a little bit of consumer welfare gains from a merger. It is possible that part of that assessment can do that, and in fact, the Commission has been doing some of that in cases. So I think that is an area that one might want to think of that. A third area that I highlight in the paper is that this duality that you see in competition, in merger control in particular, in competition policy, is finding its way into probably a dilution of the idea of competition. So in a recently contested merger case, the Mediclinic case, which you may have noted, which went all the way up to the Constitutional Court, it was ultimately held that harm to a subset of vulnerable consumers, as it was called, that harm from the merger, in this case it was a hospital merger in a particular vicinity, that implies unacceptable harm, and that it should be blocked on that basis. So what is implicitly happening is not only are we thinking about non-competition issues as a separate set of issues, but within the competition assessment, there is now a tendency to start thinking of it not as rivalry. Now, of course, the effects are critical. I mean, nobody would deny you. We want to think about the effects, especially on the poor in these cases. But we will need to think very carefully how much we're willing to do that and how proportional all of this is. So how much are we willing to sacrifice when we get to mergers? In this case, I was involved there, but I mean there might be certain gains that you're giving up implicitly if you're focusing on blocking a merger just on vulnerability grounds and focusing on specific vulnerable groups to the exclusion of others. So there are deep problems there about kind of how we think of competition. So I've made more explicit set of proposals that maybe the discussants want to talk about, but I think the kind of bigger thrust in the paper is to say, well, we need a reevaluation, and for those again more familiar perhaps with central banking or other areas of policy, we need to heed the Tinbergen rule, right? You have one policy, we have one policy instrument, but you should be careful in thinking that you can pursue two policy goals with the one policy instrument. It is in vogue to say, yes, but everything should account for the complex conditions in the country, and of course, one doesn't want to ignore that. But you'd need to think about ultimately where the emphasis is going to lie in a specific policy area. Is it going to be competition or not? If it's competition as originally conceived in the Act, then there is a secondary place for a set of public interest factors, but we need to think about which factors that should be. And that in turn requires us to think about what has been the benefits of these conditions that we've been imposing. What evidence do we have on that? Because, I mean, of course, in smaller transactions, maybe the cost is seen as small, but in many transactions, in the larger ones, these can be very substantial. So what are we happy to accept that? What are the gains there? And what's the messaging from that. Of course, as Vashia said, now subsequent to the paper's publication, what has happened, and I want to just add that, the government has announced some kind of welcome and I think important changes to the merger notification threshold. So the thresholds require you to notify a merger that exceeds a certain asset or transaction value. And that has been changed. So that means that there will quite a number of smaller mergers no longer be notifiable. So that is welcome. I think that is an important part of the story. And of course, also certain mergers will no longer be viewed as large mergers and the attendant additional scrutiny and resources required there. So in my view, I think this is exactly the types of reforms we need, kind of focused on the competition, maybe reducing resources, but we should add to that a kind of more competition-centric focus that can help us improve productivity, improve general dynamism, and actually raise growth. So I think I'll leave it at that, and maybe we should have a response. Thanks. Thank you.
Should I go ahead?
Sure.
Thanks, Willem, and thanks for the paper. So for those of you who are not too familiar with our competition setup, we have the Competition Commission, me, which does the prosecutorial, and then you have the Tribunal, Thando, who does the adjudication. So we've separated those roles. And there are two parts of the system which are important. And I thought maybe just to give our reflections, as the Commission often sets the agenda as a prosecutorial body and has to do the first investigations, as to how we're thinking about pro-inclusive growth competition policy. I mean, the one thing I welcome is as Willem said, competition has few friends, and certainly competition agencies have very few friends at the moment. And I think what's lost in the debate at a time when we have a growth crisis is the role of competition. But if we listen to almost every session that we've had so far, competitiveness comes through all the time. And injecting competition in especially state monopoly areas to bring about lower prices and more supply is a key feature. And yet, if you look into the public debate, it's competition law and policy is getting in the way of investment. You know, who cares if this is uncompetitive merger or an uncompetitive act? We want the investment. And I think that's problematic. It's deeply problematic. You know, we need to focus on the competition, as Willem has said. I think the bigger point, just as a starting point for me, it's not pro-growth, it's pro-inclusive growth. That's the objective of the GNU. That's accepted by all parties in the GNU. And I think we've heard enough about how inclusive growth is important, because you've got idle assets, human capital, entrepreneurs that are excluded from the economy that need to get access to the economy. We've heard about the level of concentration and the issue of entry, exit, and moving up the value chain, expanding. So we need to have the inclusive part of growth, and we can't forget that in pursuing just growth alone. The public interest, in our view, is almost a misnomer. We think public interest, in fact, is about competition, largely. It also provides the inclusive aspect as well. But if you look at the statistics for South Africa, our SMEs account for, on our latest exercise with the SARS data, 22% of turnover. The OECD average is over 50%. So we have a gap there, and of course, black-owned businesses do face continued exclusion from the economy, as old networks tend to support the same firms and the relationships between them. Competition policy is not very good at longer-term dynamic assessment. We tend to look at very near assessments, even on competition. But we need to build an ecosystem, a strong ecosystem of entrepreneurs, SMEs, and inclusive of black-owned businesses that can bring that dynamism to to the economy. And that has been emphasized in many of these presentations about bringing dynamism, bringing challenges that impose some rivalry and force people to invest, to respond to that. So a lot of the work around public interest is the participation of small business and black-owned business, and I think we see that as part of a broader building a competitive economy and a dynamic economy. On the sort of pro-growth or pro-inclusive growth tools, we've actually taken some guidance from the OECD that issued a paper on pro-competitive industrial policy. And I suppose merger control you could see as a red tape issue, and so issues of time and all of that are clearly important. But I think the bigger issue is about what competition policy can do to remove barriers to market access and regulatory barriers in the economy. And we've heard a lot that South Africa suffers from high levels of regulation that exclude. And often if you're an economist in sort of regulatory theory, which I was maybe 25 years ago, often it's large firms that put up regulatory barriers because they can comply, but they know their rivals can't. And so often these are anti-competitive by their very nature. The other aspect that the OECD puts emphasis on is being very clear about pro-competitive cooperation and trying to ensure that where cooperation can in fact build competitiveness without undermining competition, then it should be encouraged, and authorities should be much clearer on that. So that's where I think we've probably headed, but we do recognize the issue with merger control, and that is something we need to fix. I think as Willem said, I think the debate on merger control is influenced by a few mergers that take a hell of a long time. And that is problematic, and we recognize that. But just on the sort of statistics, only 6% of mergers, if we're looking at the last sort of financial year, took more than 60 days or 12 weeks, 3 months. So 94% took 3 months or less. We phased them by sort of phase 1 being not very much competition issue, to phase 3, which is quite serious competition issues on first examination. And it's only your phase 3 large mergers that take more than that 60 days. And in any one financial year, it's about 5 mergers that take more than 100 days. But of course, that is still unacceptable. And I'll come to what we've done, but you've mentioned part of it already. What we do see is that public interest is not the cause of delays. All the cause of delays are these large, potentially anti-competitive mergers that are either complex to analyze or where we prohibit. Those mergers then move from us to the tribunal. Either we've approved them subject to conditions or we've prohibited. And if we've prohibited, then the tribunal will look to assess under appeal or review whether that decision was good, and that's brought by the merging parties. But where we've approved it conditionally, what we do see is the high presence of interveners in mergers that are likely to affect, and where other businesses are dissatisfied with the decision of the Commission and is using the process to maybe secure a better deal for themselves or to trip up a rival. Some of it is genuinely bad faith. And where we see the sort of time issue is you've got a competition commission time and you've got a tribunal time. And the tribunal time can take considerable amount of time if there is intervention and if this is a complex merger. And so I think from our diagnosis, we have to fix at the Competition Commission those 5 or 6 large mergers that take over 100 days. But we also have to fix what's happening at the tribunal to ensure that that process can move more smoothly. But as I said, these are because of competition, not public interest. Public interest, also as Willem indicated, has never resulted in a prohibition. There was one merger, the Burger King, but the facts behind that was we ran out of time, our statutory time, and we were in negotiations, but we continued negotiations and it was settled. But outside of that, nothing has ever been prohibited on public interest, and the courts have approached this as you can always fix public interest with a condition. And therefore, I don't think the risk necessarily exist going into the future that that's going to happen, that we're going to prohibit. I think Willem raises the important debate of, are we chasing away, and I think the public debate has been foreign investors, and as Willem points out, what we can look at is mergers that are notified, where public interest is imposed, and none of them have been abandoned because of that. And we've had big foreign investment. Heineken, down the road from here, PepsiCo are all examples of substantial public interest obligations, but also substantial foreign investment. So it is a difficult question to address because it's one of almost judgment, speculation, and ultimately probably ideology, whether one believes that that's the case or not. I think the bigger issue, which I just want to get to before I talk about what we're doing, one of the bigger issues, I think, is merger control is caught up in a transformation debate, and it's a transformation debate. Yes, it impacts merger, but mergers has become a proxy fight for the fight over transformation. And because in the 2019 amendments, we introduced a positive obligation to improve the greater spread of ownership. So it brought in an ownership dimension. And that is subject to quite big attacks at the moment from not just within competition law, but broader. But competition law is binding. We have powers we can impose. And we have imposed employee share ownership schemes, other transactions to improve ownership where it has happened. But I think labeling public interest as a problem when people are really fighting transformation from an ideological perspective is unfortunate because, as I said, public interest really we see as pro-competitive. We think the ownership part as well is quite different because a lot of the public debate about transformation has been, and this may not even be correct, but has been about 100 people have earned billions from transformation and it's not been broad-based. Almost all the merger conditions imposed are employee share ownership schemes, which, to be frank, is broad-based, but it's also has benefits to many of the firms, and many of the firms see those benefits. PepsiCo came in and gave 15% away to workers, sees the benefit from productivity increases, sees the benefit from being more inclusive, retention of people. So I think even from a transformation debate, what's happening in the competition space is considerably more broad-based compared to that. So just to wrap up, what have we done? As Willem said, we're changing the thresholds. So they haven't been changed for 9 years. We did research before we put forward to the minister what these would be, but they're effectively almost doubling the thresholds. Our assessment based on 3 years of mergers prior to this is if we had these new thresholds, 25% of mergers would not be notified. So this is a huge impact on reducing red tape. 40% of intermediate mergers would not be notified, and 23% of large mergers would become intermediate, which means they're subject to a statutory 60-day process, no chance of extension. So the objective there is to release resources, not to cut the staff at merger, and to put bigger teams on the complex mergers. And we're putting in targets, the famous APP targets of government, to commit to maximum days for large mergers. The other issue is the tribunal, and I'll leave Thando to address that, but it needs more capacity, and we need to balance fair administrative process with speed, and we need to find a way to balance that. The other thing we've been doing is, and in line with what the OECD has recommended, being clearer on pro-competitive cooperation. So there have been exemptions for exporters to cooperate. There's been exemptions for logistics, for companies to come together and sort that out, and in energy. And if you look at some of that, a lot of it may not necessarily fall foul of competition law, but it provides a certainty to business that now they can do it. So for exporters, it's designed to overcome an issue, which is sometimes you need to jointly invest in export infrastructure, whether that is joint shipping, warehousing, etc. but also market intelligence. So I think our concern is some of this is not being taken up in the same way, and the knowledge of it, and maybe this is an area we need to be better on, is advocacy on sort of looking at how we can make sure people are more aware and take part in that. The other thing we're working on right now is deregulation. We should have more of a role in Eskom and Transnet. We need to make sure. We've seen in telecoms that state monopolies tend to be resistant to losing that monopoly, and tactics are used to enforce that. But we also need to advocate within government on where regulations are restricting business expansion or entry, and unlocking that so we can get the challenges through the rivalry and the dynamic benefits. I know I've taken a long time, but thank you for giving me that time.
Thanks, James. Nicola?
Good morning, all. Firstly, thank you very much, Willem, for the paper. I think what the paper does very well is it frames the problems and the challenges very well. I think we need to think very carefully about the potential solutions, the ones that Willem have put on the table, but also those that one grapples with, both from within the institutions, the Commission, the Tribunal, but also really from the private sector. And I think all of this fits in very well with what was set out yesterday also by Dan in terms of a regulatory reset. I think he framed it very well where he said that the issue is not really the goals, and I'll talk a little bit about the goals of the policy in South Africa and the public interest goals, but it's really implementing these goals and minimizing any economic distortion. And I think that is where we need to focus at the moment in South Africa, because I think one can argue it either way, but there has been economic distortions. In terms of the research, again, there's been very good research from Willem and some of his students, Changole and Boshoff and Morris, that shows us that these mergers, the larger ones especially, which are important for economic growth and dynamism, they take longer, there are significant delays, and also there's an increase in conditional approvals. And what that really means is it has an impact on certainty, and that is important for investment. So I hear your point, James, that investment can't trump an anti-competitive transaction, but I don't think that's the issue. The issue here is that firms, and these are large firms, need certainty for them to notify these transactions, to enter into these transactions, and they need to know what kind of conditions will be imposed and how long it will take for such a transaction to be ultimately approved. I fully recognize the role of interveners, which can delay these processes by months, where the two retailers would like to merge and they want to, benefit from some of the synergies and the scale. They might see a 2-year delay if there's an intervention. So we need to get rid of these kind of opportunistic issues in terms of the application. But what I really want to deal with today then is with public interest. I want to talk about that a little bit. And then also the other thing that I think James left out really is the role of the minister. I also want to talk a bit about that, because that is important, and I think this is where, James, you've made the point that delays have not come from public interest, but parties to a large transaction, maybe Heineken Distil is a good one, they meet with the minister and they negotiate a package of public interest commitments that come with a framework agreement to the tribunal. And that's something that has really occurred on the sidelines, and I think one needs to actually curtail that. Because Willem's paper proposes that you limit the powers of the minister. I don't think it's necessary to do it in a statutory sense, but you need to do it in a practical sense, where the parties should have some indication that they don't need to offer all of these things to the minister to get a transaction through, but rather let the Competition Commission and the Tribunal use their independence and actually adjudicate on the merits of the transaction. So the issue with the public interest, and I just want to briefly maybe touch upon that, because we've had a very good recent decision by the Competition Appeal Court. Those of you that follow the competition processes would have seen the comments on the recent Vodacom and Massive merger, which took quite a while, and was finally approved by the Competition Appeal Court. But what they reminded us of is that the public interest criteria, especially for merger control, is a closed list. So we've been hearing about industrial policy, trade policy this morning. So there are 5 factors there. Deals with industrial policy, deals with trade policy, deals with black economic empowerment. We will also hear about more in the session later today, deals with small enterprises and deals with employment. But one of the proposals of Willem's paper is that we tighten the list of public interest factors, that we potentially reduce them. I don't see that happening. We've had the recent amendments in 2018, and I think it's rather a way of applying them in a very strict fashion and arguing, that these are the 5 criteria that we look at. If industrial policy is closer to competition policy, there's already a criteria included there. I always tell my students as well that South Africa is not some basket case in terms of including other non-competition goals. The UK CMA prohibited the NVIDIA ARM transaction on security grounds. So we are in line with international best practice in this sense, but I think we need to apply it, as the Competition Appeal Court has indicated now, as a closed set of public interest goals, and these shouldn't be expanded also by parties to these transactions for their own benefit. I think there should just be a tighter application of public interest in that aspect. Then this whole idea of the vulnerable consumer. I think that is something which we again need to be very careful that that doesn't fit into or flow into our public interest criteria. That's why I feel strongly that the public interest criteria is a closed list, those 5 factors when you look at mergers. The idea of the vulnerable consumer, again, if you think about it just from an economic point of view, microeconomics, you don't really want to distinguish between different consumer groups and start estimating maybe different elasticities. But it has entered our jurisdiction through the Mediclinic judgment, which Willem also discusses in his article, where there is this idea that competition policy should do all of these things in terms of redistribution, equality. I agree with inclusive growth, but we can't ask the competition authorities and the Competition Tribunal, the Competition Commission, to fulfill all of these mandate. So again, I think if you want to think about the vulnerable consumer, and this is also what the paper suggests, is you have to do that then under your competition test. So it's not worth the Constitutional Court saying in Mediclinic, for instance, that, and think about the vulnerable people that can't access a private hospital. It needs to be done within the framework of a properly defined market, estimating those effects. None of these things is easy, as Thando would also explain. Ultimately, the tribunal needs to weigh the competitive analysis with the public interest criteria. And although there was a secondary role for public interest prior to the amendments, we now know that these are to be weighed equally. And that requires, obviously, a balancing act. I think it's more of an art than a science, but still we have to apply our economic tools in order to ensure that we think systematically about how we adjudicate these things. So, I mean, in sum, I don't see us reducing the public interest list. I think it needs more consistent application. I think in terms of the role of the minister and the recommendation that the regulatory authorities become more independent or even be moved outside of the DTIC, I think it would be better to keep the role of the minister as it is. Currently, the minister can intervene in these transactions. Again, in the Vodacom Massive one, the minister took actually a supporting role of the transaction. But I think what needs to happen here is that the parties engaging with the minister and lobbying the minister, I think outside of the ambit really of the tribunal and the commission, I think that needs to be limited. And that would also help in terms of the time frame for these transactions. But I think we do need something of a regulatory reset here. There's been criticism, and James, I accept your issue about the thresholds being changed, but I think it's also a very welcome development, but maybe a bit late in the day. And I think we need to think very carefully about the road ahead and reforms that would help and strengthen the authorities also in terms of capacity at the tribunal. Thanks. I'll hand over to Thando to pick up from there.
Thanks, Nicola. I mean, hi everyone. And Willem, thank you for this, because I think it's, and just to recognize that there's very little, and I think insufficient scholarship in our country on these kind of complex questions. And so that you guys and your team kind of continue to put up papers in this space to provoke thought, I think is an incredibly powerful thing. And I hope we can discuss how we can do more of that, really, going forward. Because there is a sense that we are lacking an evidentiary basis for having these debates about the kind of the workings, the application, the interpretations of our Competition Act, right, which embodies this kind of very theory-based industrial organization, theory-based interpretations of how markets work and the rules around those to achieve competition. But whether we like it or not, they also then include, in very powerful ways, including in the preamble of that legislation, provisions to say, in our processes of thinking about building competitive markets, etc., the authorities or the agencies ought to have an eye on inclusion and redress in the process. Now, in a sense, for me, and maybe this is a starting point, is the rules of the game are set. They're set because we did the amendments, and it takes really long to do amendments. And in South Africa, there's a clear instruction that we will do competition policy or competition law alongside redress. It's a very powerful and unique microeconomic tool and legal tool, is because you get to see kind of the underpants of firms in ways that I think in other sectors we don't, right? As economists, in that you get to interact with their kind of internal costing data, financials, the kind of planned efficiencies and visions around how synergies might arise, their due diligence documents, etc. So we get a lot of information, access to a lot of information about how firms are thinking about their positioning in the market, etc. And this is an incredibly powerful tool, right? Because it does mean that we shouldn't ignore the opportunity to also see how that insight about the inner workings of markets, as opposed to maybe some of the more aggregate kind of macro concepts we've been speaking about, can allow us to design better for some of the problems of inclusion, but also some of the problems of weak competition in our economy. And I think this is actually where the conversation ought to be. So I think that in our space, and I think James has characterized it well, is that there's kind of a strong public concern, if you will, particularly from private firms, journalists, etc., often speaking under anonymity, of course, to say there's these problems of uncertainty, and then there's this kind of risk of serious interference in the work of the authorities. My sense, though, as kind of observing the institutions, is that I think our institutions are somehow, in all the kind of political turmoil of our society, in the kind of state capture era, etc., have been very resilient in terms of maintaining relative independence, doing work against what the law allows us to do and not going beyond that by and large, and essentially continuing to deliver on the kind of relatively narrow mandate of those institutions. I think that's important to remember, because if you pick up a business day or something today, you might think otherwise, and then that's just, I think, part of the nature of the game, I guess. So for me, the question then is really a question of application. So with that context in mind, with that understanding of the institutions, the question is, within these rules, how do we improve how we apply our public interest tests? How do we improve the kind of theoretical underpinnings of how how we might actually really assess public interest factors, etc., within our competition law regime, right? As we have done in the very well-developed literature on the competition side of our work. And I think more work in that space to tell us what works but also what doesn't is going to be quite important. I mean, I think, and I kind of segue to my second point, is that some of those remedies I think are really important that the competition authorities can impose, because they have to do also with the ability to ask of firms to commit, for instance, to procure from firms owned by historically disadvantaged persons, or to, on the participation aspect, to do certain value chain related commitments to say we will, for 3 years or whatever the case might be, procure certain types of inputs or whatever the case might be from smaller firms or historically disadvantaged firms. I think this is a good thing by and large, right? But of course it must be met with the equivalent requirement to our law, is that they must be responsive to a certain harm that's identified. They should not be arbitrary, these types of conditions. I think that's where the uncertainty arises. But maybe we just have last few moments. I want to make a second category of points, which is that the paper departs from the premise of weak competition in our economy, in a sense, and kind of this idea that, of course, competition, if it worked, would drive innovation and growth in our economy. And I think this is absolutely agreed. It's not a thing we can debate about. But I think the problems of weak competition, linked also to some of the things that Dan spoke about yesterday, are much more broader in our economy in ways that I think the competition authorities can help play a role in addressing. So in my mind, for instance, these conversations ongoing about introducing competition into our electricity generation space, our distribution space, and having a kind of competitive electricity market, these are conversations which these authorities, and certainly James and his team, should be part of. My understanding is that they're not, and I think this is quite surprising to me, because of the knowledge and insights they have through the transactions, through the competition cases, about the inner workings of firms and markets in these markets, right? And so these are things that your energy regulator ought to have sight of, so that we can design better for this market. And so those connections aren't necessarily always happening within our broader regulatory space. And then the obvious kind of constraints that I think ought to be addressed with better integration. I was glad to hear Zuki talk yesterday about that there's an ongoing process of putting up a new industrial policy, right? I would hope, in fact, that that's in conversation with the competition authorities, because what we should be thinking about is a pro-competition industrial policy, linked also to kind of some of the things that Lawrence was speaking about. And there's a range of things that I think we would need to focus on under such a provision, including issues of barriers to entry. Whether the firm is black-owned or not, there's a serious constraint facing particularly dynamic medium-sized firms in terms of seriously engaging in value chains and essentially taking on what are usually tight oligopolistic positions, right? This is just endemic, and I don't think we've thought enough on that side of the conversation about how to unlock some of those things. I think the market inquiries tool, which some may not know, is a kind of provision within the Competition Act that allows the Competition Commission to also look at entire sectors and value chains and kind of try to see where competition problems might lie, what are the constraints to dynamism. And that includes even looking at kind of certain regulatory constraints where the state itself is in the way of competition and dynamism, and make recommendations around that. I think that's where the focus should be, on those types of tools if we're talking about enhancing competition policy for growth. Thanks.
Right. Thank you, everyone. I think that's great. I think there are a variety of issues that I think were interesting for the four of us, but I think for this audience, I think specifically the point that was raised both by James and by Thando now again emphasized the importance of the sort of sectoral policies, other regulations that shape the competitive environment, and really what can you expect from competition policy on top of that. I mean, it's easy to say you're supposed to be dealing with concentration because that's in the Act, but if the concentration is generated by other forms of regulation, then that's there's only so much you can do. And many of a lot of activity say, in telecoms over the past 20 years have been around trying to deal with mergers and interventions in behavior. That's really the result of kind of problematic regulation, sectoral regulation, actually. Maybe we should just open the floor to see where the audience wants to go. Yeah.
Hi, Dan Andrews from the OECD. Thanks a lot. That was super interesting. I've got so many questions that I don't know where to start. But so I don't know anything about the South African situation, but you mentioned a few things that I found interesting. One is that you've raised the threshold for notification, or in terms of the merger system, right? So that's different to what's happened in other countries, right? For instance, my own country, there's a concern about declining dynamism, and that there's many mergers that have flown under the radar, right? Because big incumbents are swallowing up startups, and that's been bad for the competitive landscape. And so I guess my question is that if there was a more singular goal of the competition authority, right, based primarily on competition, would you have more resources to basically adjudicate more M&A activity so that you wouldn't actually have to raise the thresholds?
Thank you. My name is Laura Lynn Kaziwani from DNA Economics. My question is coming from an industrial policy perspective, and I'm just reflecting on the AMSA excessive pricing that happened a few years ago, as well as the SAB InBev merger. So in both of those, there were conditions related to industrial development, securing supply chain, conditions within the country. But my experience or my research has shown that weak enforcement has undermined some of the industrial development outcomes. So how does enforcement play in this? And does the Competition Commission or whoever is responsible have enough institutional capacity to deal with enforcement?
You first, sorry.
Okay. So, Vuya Jack. So I found this entire discussion so fascinating because there was so much collective wisdom that is inherent. So when you look at the paper, looking at the past and the results of unbundling, and then you regulated it, and then you're able to see the rise, because through the unbundling it was almost like a Wild West coming after apartheid. And those are the similar lessons we've seen in other areas, of course, under the control of the DTI, in terms of the different waves of BEE. And when you also talk about now balancing the competitive factors and the non-competitive factors, it's the same lesson we've seen within procurement of the triple PFA, where they say pricing vis-a-vis other factors, which is RDP, and it morphed into transformation. And the same lessons repeating itself within the competition arena, and the amendments that came through to be able to then regulate how, in terms of the notification. So when you look across government, there's so much collective wisdom, but the problem is that those intersections are not taking place to harness that collective wisdom. So what you might be assessing from a from the competition perspective on the non-competitive factors might be something that has already been addressed on another side, like in telecommunications, because of having quite a lot of experience in that, or within the National Treasury in dealing with the triple PFA factors. And therefore, the cross-pollination of that wisdom is quite important. Therefore, we need to see more papers like this, because your paper raises this point so beautifully, but you can actually bring certainty because we can use collective wisdom that we've seen the pitfalls of if you go this route, and then you can avoid it. So you can be able to then, when you raise the notification factor, you can be able to front, because you can make sure that your mergers and acquisitions are below that threshold and still be able to then achieve uncompetitiveness. And therefore, but there are measures on how do you mitigate fronting or stop fronting from other parts of government. So I commend you on the paper, and I love the responses because they are progressive responses that are able to say, we have a goal, and we're not going to shirk on that goal. That is competition plus redress. But how we address redress, we can be able to look at the collective wisdom that is elsewhere rather than reinventing the wheel. So we would love to see more paper and more collaboration that could arise in harnessing the collective wisdom that already exists within government in terms of addressing these issues.
Okay, I think well, you've been waiting a while, so yeah, maybe last.
Anthony Altbecker. I was wondering, I mean, I know the focus of the paper and the discussion has been on the mergers work, but the authorities also have the market inquiries instrument, and I wonder if those, I'm asking out of sheer ignorance, but has anything useful been done with those? Could they be used more productively to promote competition and dynamism? Or should we not look at that as a viable tool for doing anything productive?
Okay, seems like lots of questions. You're going to be best placed to answer, James. If you want to have a go.
Well, let me start just with the first run through with. So Dan, what we did was when we did a sort of look back, what I didn't mention is we also assessed what happened to those mergers that would have been below the threshold. And the results were 75% were unconditional approvals, so it just went through. 3 of them had a competition-related condition, but minor, more about information sharing, sort of director controls. And then there were some small public interest ones that, to be honest, were sort of less than 2% of the public interest. So we had that assessment, but we also have the power to call for small merger notification where we think. But what you're right about is everyone got worried about killer applications in digital, and so they wanted to, in fact, reduce their thresholds more than anything. And this is something, you know, we've raised in some of the other forums. They're working hard to fast-track mergers that don't raise competition, but it's simpler to raise the thresholds and keep that power. So we think this is a better outcome. And that's how we sort of approach it in future, more scientific, but we need to do thresholds more often. On this sort of enforcement, I assume, Laura Lynn, you're talking about compliance with merger conditions. And you're right. I mean, I think that's one area we need more capacity. And I think it's one where we've started doing research. So we're about to release research on employee share ownership programs to look back at what has happened and how can we improve design and compliance moving forward. We're planning one on procurement as well. But we need to make sure that whatever conditions are effective. So we've done some on competition conditions, but we're now looking at also the public interest conditions. And I think we've got a session later, but the BE Commission has found often that, you know, enterprises and supplier development is tick box and not always delivering the results. We might find the same in some of ours. Buyo, thanks for those encouraging words. And I think, I mean, what we've taken on board, what this administration has pushed is all of government approach. And we've taken that on board and trying to forge partnerships. So, you know, we have a partnership with the BE Commission where we can work on joint issues around transformation and compliance and fronting, as you say. But also on the competition stuff, we have joint work with DALRAD on agricultural markets. We have joint work with Department of Health. We have joint work with Department of Communications. So we're finding that is incredibly effective. So to take a case, Johnson & Johnson had a secondary patent on an important TB drug. We initiated an investigation. Department of Health called for a renegotiation. Civil society got involved. And in 2 weeks, they dropped the patent across 134 countries, and the price was halved. And so that's quick impact, which you can only deliver, I think, when you're using all the tools of government. Anthony, nice to see you again. Market inquiries have been really important. So just to take some of the things we're talking about, a grocer inquiry ended up removing all the exclusive leases of your big retailers across all shopping malls, which was critically important to allow smaller businesses to come in, or even for Boxer and USAVE to go head-to-head against each other in the same proximity. The data inquiry saw a reduction in prepaid prices of 50%. We've had the online inquiry, which looked at how to open up the platforms to bring firms, especially smaller firms, onto them and get visibility. As a result of that, Takealot onboarded over 800 black-owned businesses in the first 14 months, and we've seen savings in the tens and hundreds of millions of rands for small business. And then the last one was also your media inquiry. So the media has benefited from some of the platform access. So we think it's a critical tool because what makes it different is it's about making the market more competitive. A lot of what your competition tools are almost trying to prevent things getting worse. So merger control is about preventing markets becoming more concentrated. It doesn't help restructure them to make them more competitive. And even your abuse of dominance is stopping conduct, but it's not changing structure. So I think market inquiries are a critical tool, and we've used them also to get bigger things done quite quickly rather than relying on protracted court processes.
So if I can maybe respond, I'm not going to respond on the thresholds because I think that's a good thing and James has already answered that. But I think there is a point to be made about the question about SAB InBev, because I think that takes us back to the paper where we talk about competition issues and then public interest issues. And remember, we said that since the 2018 amendments to the Act, these carry the same weight. And where I've been talking about the predictability and certainty in terms of investment is I want to use an example where when you do the competition analysis properly and you then craft a condition, one very good example actually is the merger that James also referred to, the Heineken-Distell merger. So in that case, for instance, the parties notified the merger and they realized that there will be an anti-competitive competition effect on the cider market. And the condition then crafted to address that issue was that Heineken would sell their Strongbow cider. And that's really been a success story because it was sold to a smaller brewer. They've now they've built a new brewery in Gauteng. So one can, if you identify the anti-competitive effect and you can craft a condition, for instance, like this that leads to investment, I think that is a very good thing because you solve the competition issue and you also have extra investment. When it's a public interest condition, I think there we probably need a bit more research, as you've also suggested, on the employment share ownership schemes, for instance, about some of the SMME and the supply chains. I don't want to comment on SAB InBev, but I think an example there, for instance, is the Pioneer PepsiCo merger, where there were certain investment commitments that were made at the time, which unfortunately was in the same month as COVID, March 2020. And there the parties then also had to apply for a variation agreement because they couldn't actually get to those investment thresholds. So I think what is important is that these conditions should be proportional, that they can be committed to, and obviously the Commission also needs to have the capacity to make sure that these are enforced and policed. And I fully agree that if it's a too complicated behavioural remedy package, for instance, too much policing from the Competition Commission, then that becomes problematic. But I think that's why it's very important, again, to think about your competition issues and the public interest issues. Then just briefly on the market inquiries, I want to differ from James, but also maybe compliment the Competition Commission that since the amendments, the inquiries have to happen within 18 months. And I think that is a good thing. Because prior to that, we had the grocery inquiry, and I want to talk maybe a little bit from private sector perspectives on the health market inquiry, for instance, the grocery inquiry, the data inquiry. We always had a client, and you have to supply data and attend for 5 years inquiries, and then there's maybe 1 or 2 recommendations that flow from that. But what I would say is, since the amendments, the platform market inquiry, for instance, or the media inquiry, those are more targeted because the time frame is limited. And I would certainly agree that from the platform market inquiry, very interesting lessons and also good recommendations. My one concern, and I don't know if you want to answer that, but whether that knowledge that is gained by the market inquiry division, whether that flows through into, for instance, people that investigate mergers in different sectors. But I think generally the market inquiries have been good since 2018, since the amendments. Thanks.
Yeah. Appreciate. Can we do another round, or no? No. That's very firm. Thank you very much. Thank you.